Welcome to Southwest Florida Real Estate Update, hosted by local realtors Jim, Michael, and Morgan York of the York Real Estate Group of Downing-Frye Realty. Our show will bring you the most up-to-date information on the local real estate market, featuring the leading experts in the real estate field.
Hi, and welcome to the Southwest Florida Real Estate Update. I'm Michael York of the York Real Estate Group, and today we're joined by our host, Jim York, and his guest, Don Ross Jr., President of Ross Title and Escrow.
Thank you, Michael, for the introduction. Well, Don, thank you for coming on the show this month again.
Thanks for having me, Jim.
So let's just tell people that haven't seen you on the show before a little bit about yourself.
Well, I'm a lawyer, unfortunately. That's what I do. I'm a real estate attorney, been so in Naples for 25, 30 years. I'm one of the owners of Downing-Frye Realty, been in-house counsel for 25 years or so at least. So I've seen all the issues the agents might bring up. I own Ross Title and Escrow. We've done 20 to 30,000 closings. We've got 7, 8 employees, been with me from over 30 years. One 20 years, another one 10 years. I've got 4 members of the same family together, so it's a really tight, cohesive group. I actually enjoy going to work and working with them. And I have my own law firm too.
Well, I know our clients are very happy with you, so I know the communication is a big thing with you and your your closing agents, so everyone's really appreciates that.
Thank you. Appreciate it very much.
Today on the show, I know this year's been a good banner year for us, for everyone. So I know when we're getting contracts from other real estate agents or whatever, sometimes they're not being filled out properly. I mean, just because maybe they might be newer in the industry or they haven't had the training. So I wanted to do this show a little bit about talking about what problems there are with incomplete contracts being filled out improperly. So maybe I could let you start with that and list it, and then I could put my 2 cents in. Okay?
Both 2 cents.
2 cents.
Okay.
I got it in my pocket.
Great. Well, yes, we have so many forms. In between the Naples contract and the state contract, the FAR bar contract, we have approximately 150 forms. And for any one customer or any one agent, it's close to impossible to understand and integrate all of them. And we invariably run across certain things that pop up all the time. Probably number one would be having the wrong parties on the contract.
Right.
Unless you've gone to law school, unless you specialize in the area that I do, you don't necessarily know who the seller needs to be. We have a part of our Florida Constitution that deals with homestead and your ability to convey it. And in many cases, people will look at, you'll have an owner who says, well, it's in my name, and he or she lives there with their spouse, and they think they're the only ones who need to sign as the seller, and that's not true. If it's their home, you need to have the husband or the wife, as the case might be, join in on it just to satisfy the Florida Constitution. Even if it's in a trust, if it's in a trust, I get agents asking me all the time, who signs on? And I always ask, is it homestead? And you can look at the tax rolls. You get people who apply for homestead, but they tell you it's not homestead, but they applied for it because it saves them money. So the fact that it's in there in the public records is enough to require both the husband and wife to sign. If it's in a revocable trust, you get everybody to sign, bennies, whoever they might be, the beneficiaries. So I tell the agents, if in doubt, get everybody to sign. If it's a limited liability company, like my office is owned by a limited liability company, I'm one of the members.
Right.
You get all the members to sign. You don't know if one of the members has the authority to sell the whole thing. So you don't want to get 3/4 through the closing process, have the buyer spend a lot of money on inspections, have Jim York spend a lot of money advertising and open houses and things like that, staging the property, and then find out that you're missing a member or you're missing a shareholder from a corporation, or you're missing somebody's spouse. They might be separated, and they think, wow, we're separated. I don't need that person. And I've had that many times where people have been separated for a long time. They live separate lives.
Right.
And what do you mean? We don't even live in the same place. I need to get my wife to sign? You do. So that is probably the biggest thing that we run into, and it's a little frustrating because, you know, how do you train a realtor?
That's right. How do you?
And all I tell them is, if in doubt, get everybody.
They sign.
Get everybody. If you have somebody who passed away, get all the heirs. You know, and I'd rather have too much than too little.
Right.
That's my philosophy. I'd rather have too many people agreeing that they're going to convey the property, even if they don't think they have an interest in it. Get them to sign up front before you put in a lot of work, before the buyer spends a lot of money doing their inspections and so forth, before the lawyer or the title company spends a lot of time. You know, that way you're more apt to have the closing occur. So that'd be number one on my list. Okay.
How about mortgages, filling in the proper what down payment and what's due? You know,
mortgage.
Let's say they put down 10% down and they're getting a 90% mortgage, and they end up the bank says I got to put 20% down. Does that affect the way they fill the contract out or not?
It does. I mean, under the Naples Board of Realtors contract and the Florida Association of Realtors contract, you're supposed to apply for the mortgages in the contract. So when your buyer goes to, you know, whatever lender, and hopefully it's a local lender.
Right, exactly.
Hit that point again. You always want to use a local lender. They find out right away whether that program is even available. 90% financing for this.
That's right.
So they, you know, typically, like under the Naples contract, they have 5 days to apply. So that any decent loan officer should be able to tell their customer right off the bat whether or not they even offer this program. And this is where, you know, Jim York having a team that includes a mortgage lender, or you know Don Ross knowing mortgage lenders, is hugely helpful to people from other states where they have different programs in place, different customs they're used to. Really comes into play. You can get your loan officer that you've worked with 8,000 times already, who can pre-qualify the people and tell them day one, do we have this program? In fact, you probably could just call them on the phone when you put together the contract.
Yeah, we can do that because jumbo loans are different than, you know, lower price. So it is, and most people don't know that, or, you know, could be the buyer, could be a real estate agent or whatever. It's a complicated process if you haven't been used to doing it. And same thing with a loan officer. Our loan officers have all been in the business for over 20 years, so it's not somebody that's kind of learning the process.
Well, I seriously doubt this happens with you, because you know, and you call your loan officer that you work with anyways, just like I would. But for you know, some layperson who's making an offer on a home, you want somebody local. You want an experienced realtor with a team, so they can call that loan officer. I mean, I have their cell numbers, you have their cell numbers, and you find out while you're writing the contract. So. But lots of times, like here's the NABOR as-is contract, and the financing contingency is, in paragraph 1, they have the purchase price, and I get a lot of agents who don't put down the amount of the mortgage in paragraph 1.
I know, we've seen that too.
Well, it happens a lot.
Yeah,
but when you go to the financing contingency, which is paragraph 4, it has the interest rate and whether it's a fixed rate or adjustable, and on. But it doesn't give you the amount. So, you know, you get some realtors, they might even be experienced realtors, whose clients almost always do cash. But they're not that familiar with this clause. Not realize that the amount isn't here. The contract has a lot of default time periods in it already. So sometimes the customer, sometimes the agent, they just rely on the default and they don't bother going through the paragraph with the customer. And you know, it's hard to say whether that's, you know, it's good to have default time periods or not. I mean, it's nice to be able to catch something if it's missed by both the realtor and the customer, but on the other hand, it tends to make people a little lazy too, and they don't go through it. So, you know, I think you have some risk no matter which way they do it. So not filling out the financing contingency is a huge thing, and a lot of times too, they don't put the interest rate down.
I see that too.
And you know, they'll have a default language here of, well, actually in the NABOR, it does not have default language, but I think FARBAR says prevailing. You know, the point of the financing contingency is to protect the buyer's deposit if they do not qualify for the loan that's set forth in this contract. And only the buyer knows what interest rate they can afford. They might be on a strict budget. It could be a newly married couple buying their first home, and they're watching every penny, and they're relying on getting a 4.5% rate. And if their credit is bad and they didn't realize their credit was bad, they could bump it up high enough where the payment will be bigger than they can afford.
Or they don't qualify,
Or they may not qualify. So I would not rely on the defaults. I would look at it and fill it out. So that'd be my number 2 item I see all the time.
Well, before we go to number 3, we're going to take a little short break.
Sure.
We're going to talk about the York Real Estate Group, and we'll be right back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Welcome back. Don, let's talk about number 3 here. And I think you have the buyer's election form here.
Buyer's election form, here it are. This thing is a NABOR form. It's for purchasers who wish to ask the seller to give them either a credit or remediation of certain items they discovered during the inspection process.
Right.
I can't tell you how many times I've had realtors to say to me, oh, I don't have to use this form, Don. And I said, no, you don't have to use the form. The form's a good form. I'm not criticizing the form, but one size does not fit all. It is not always appropriate. You know, the buyer could make certain elections. It's based on an inspection report, and I was looking at one yesterday, and I have to go back after this show to finish up on it, where, for example, regarding the HVAC system, they're recommending, you know, they're pointing out that the air differential is too low, and they recommend an experienced HVAC person, which is an air conditioning person, go out and further investigate. So the buyer is just asking for the seller to do all this. And the seller really has no obligation to do any investigation at all. The burden is on the buyer to do whatever investigations they want within the 15 days, and if they find something that's defective pursuant to the contract, they can ask for it to be remediated or ask for a credit if they have an estimate. So I get a lot of agents who, you know, feel like my choices are, if I'm the seller, to say they accept the buyer's election, they reject the buyer's election, or they counter it. They think this little part 3 down here, they have to do this. And I'm telling quite frequently agents, no, go item by item on what you're willing to do and be very precise on what you're doing. You can point out in some instances that the seller is agreeing to, you know, recaulk a certain area even though it's considered cosmetic. You can point out that the seller is willing to replace screens even though they're considered cosmetic under NABOR. So then the seller gets some brownie points or credit for doing something voluntarily that they don't legally have to do. But then when you get to the air conditioner that's 10 years old or the hot water heater that has rust on it, you can say, you know, we're not required to do that. And the buyer doesn't take such umbrage or outrage at their refusal when you point out the part of the contract that says that's cosmetic, we don't have to do it. And,
Right.
they don't get so angry so much at the seller because they've already agreed to replace the screens that they didn't have to do, or do some caulking. You know, I always suggest to myself, do something. Do something to show your goodwill, that you're trying to be cooperative. A little give and take makes it go a little easier, rather than just right down the line saying no, 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 no. I mean, the only time the seller really can get away with that is when there's a really big deposit down, and then they can be aggressive and say no, 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 no. But you got to do it carefully. And in those cases, rather than responding by just signing this form, I have the seller write out specifically what they're going to do and what they're not going to do and why, so it doesn't come across cold.
Cold, right.
You know, it comes across as this is what we have to do, and you got a good price, and you know, you're going to get the benefit out of the new air conditioner. Why should I buy you one when this thing's working perfectly fine? And using this, thinking you have to use it, is a big misconception. The other big misconception with this is when we have our as-is contracts,
Right.
I get a lot of people who will use this form during, say, the 15-day due diligence period to ask the seller to do something.
Right.
And the problem is, at the bottom of the form, it says if the seller responds with the B or C as to any defective items, and defective items aren't even defined in the as-is contract,
Right.
then the buyer may terminate the contract no later than 5 days after the earlier of, and it gives, you know, 2 scenarios. Well, that's just flat wrong.
Wrong, right.
This only applies to the normal, not the as-is neighbor contract. It does not apply to the as-is. So you don't want some buyer thinking that they have 5 days to cancel if the seller says no. That's not how it works.
Right.
You don't want the customer to be misinformed, and you don't want the agent being sued.
Right.
So you don't use these things for as-is contracts at all. So precise responses,
Right.
if I can nail this again, and don't use it with as-is. When you're doing your precise response, you go into the definition of defective items,
That's right.
what's working condition, and what's cosmetic. And then there's that portion that limits the liability of the seller to the fair market value of the item.
Which is not much.
You know, those 4
That's
things,
right.
and you can do precise responses. And normally, unless you have a huge deposit, you throw a few $100s worth of, you know, freebies that we're willing to do just because we're wonderful people, and it sends a nice message to the buyer. That
Yeah, it always takes 2 people. You know, it can't
Yeah.
always be one-sided.
No, you get more with honey.
You do.
You
You're right.
really do. You don't know what's going to happen after that. That the seller might need a favor.
Right.
And they might have trouble getting their furniture out on time, and they might need an extra day or so.
Right.
So you don't want to totally, you know, hurt somebody and then have to turn around down the road and ask for a favor.
Okay, before we go to our next commercial break, let's hit one more item here.
One more item. Seller's disclosure. This thing.
You tell the truth on that?
You always tell the truth. They're going to find out anyways.
I know that.
You know, even if you're a liar by nature,
Right.
they're going to find out.
Yeah, the neighbor might. I've had neighbors tell them things that you know, an inspection guy's going to find out. So that's what we're not allowed to fill this out. So we give it to the homeowner, and we tell them that, you know, just be totally honest. And that's the
Be
best way
totally
to do it.
honest and go above and beyond. And
Right.
this is where I differ from some of my colleagues. And I think it's because I've given legal advice to a real estate firm for 25 years. I've seen the complaints post-closing
Right.
from buyers. They're directed almost exclusively at the seller and the realtors. You didn't tell me the garbage disposal was broken. It could be a $2 million deal, it doesn't matter. It's the principle. You played me. You were disingenuous. You could have told me and I wouldn't have cared, but you just lied for no reason whatsoever. Or you failed to be open and honest for no reason whatsoever. So I, unlike many of my colleagues, tell people, tell them everything.
Right.
Every little thing. If they see that you go overboard, in my experience, the level of trust, you know, that you start from the very beginning carries through the entire deal, makes the process so much easier, and in many cases, it actually saves the seller money because the buyer's more amenable to certain inspection issues afterwards because the seller's a nice person and gave them receipts of work that was done so they could see what was done, which is the way you want to disclose, by the way. Give them the receipts so that it's not misconstrued or you're saying the termites are all gone. Here's the receipt. I had it serviced. Right. It's been 5 years. Haven't noticed anything since. You know, that's very helpful. The second thing with this is when you get to the signature page in the neighbor form, right. When the buyer signs this, there's language in here that anything that the seller disclosed in here, let's say the seller disclosed they had a leaky roof. Right. The roof's leaking. The buyer, when they sign, acknowledges that the leaky roof is not to be deemed a defective inspection item. So unless that leaky roof has been addressed in the sales contract as something the seller is going to fix, or that the buyer is getting a credit,
you're off the hook.
You know, the seller's off the hook. Right. And guess who's going to be blamed? Right. It'll be the selling agent. So you got to be careful that if you're going to have your buyer sign it,
tell everything.
You know, well, just make sure the buyer is comfortable that whatever is in here, they have to take it in that condition. Right. And I must confess, I get calls. I take a lot of calls in the car, but I'll be asked, should I sign the seller's disclosure, Don? I'll say no. I mean, the safe thing for Don Ross to say is no. Well, what do we do? Well, I'm talking to a listing agent. I'm saying, well, just save confirmation of your email, make a note in the file that you spoke to the other agent, and they did get it, so you can confirm they got it. You have an evidentiary trail that they were told these things, which is all you really need to do. And the seller should be okay, the realtor should be okay. So when I don't know, when I don't have time to even read the report, I'll just tell my buyer not to sign it. But you need, I got your report, but I'm not agreeing that it's a defective item. Right.
Okay, well, before we go into the next thing here, we're going to take another short break, and we're going to also have a little commercial about Don Ross's company, which is pretty interesting. Thank you.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.
Welcome back. Don, let's talk about HOA forms, combining all the stuff on them. So,
well,
fees and everything. This
happens quite frequently. Pick on Pelican Bay. They have the Pelican Bay Foundation. That's a homeowners association. There are other homeowners associations within Pelican Bay. Right. So you look at the Pelican Bay Foundation as an umbrella, and beneath that you might have condominiums, you might have homeowners associations. And I see a lot of people combining 2 homeowners associations on one homeowners association disclosure form. Right. Now, what most people don't understand is that form is a creature of statute. The Florida legislature prescribed what's supposed to be in it. And I tell people, you just put exactly what's supposed to be in there. You don't put in extra. You don't put in the golf course fees. You don't put in capital contribution fees. You don't put in anything extra. And you do not combine a homeowners association with another homeowners association on the same form. You do not combine the homeowners association with the condominium fees on the same form.
Do 2 separate.
You don't do it. This is a creature of statute, and it's one of those things where people say, well, it doesn't make sense, Don. I say, I agree. It makes no sense. But who says the law is supposed to make sense? Right. I mean, really. I mean, a lot of times it does. A lot of times the intention is good, like with the homeowners association form, to disclose, what the maintenance is. Are there special assessments? Are there any land leases? And then it goes on to talk about how if you want more information, you can look in the public records or check with the management company, and they'll have all the information you want. But if you go off that statutory requirement and put too much, you invalidate the HOA form. And that gives the buyer 3 days to cancel.
Right.
And I've had people sued over this. You know, when a buyer canceled and the seller gets upset at whoever did this.
Right.
I've had realtors have to credit money out of their commission to the buyer because the buyer will use this error to get some inspection concession out of the seller. And the seller's mad at the realtor, so the realtor puts a part of his or her commission. I've seen that a fair number of times. So another one of those situations where what the road to hell is paved with good intentions. They mean well. It's common sense. It'd be nice if the form had all these extra fees. It'd be nice if you could combine things. It'd be lovely if homeowners associations were treated the same as condominiums. But guess what? They're not.
Right.
They're not. The law doesn't always make sense. You just give them what they have, what the statute calls for, what's in that form. Don't give them too much, don't combine, and don't use them for condominiums.
That's good advice. I mean, that's good advice.
Oh, thank you, Jim.
Okay, next thing, small deposits or large deposits. What do we, I know we just got a contract from somebody, a $760,000 home, and they put $20,000 down. They told us that was a lot. So, I was trying to,
really?
I got my calculator out there and I couldn't figure out it was like 2% or whatever it was. But it was, you know, it was kind of interesting.
They're the bane of my existence. Again, we're in a state where people from everywhere buy.
That's right.
And you have some states in the country that have like $1,000 deposits. And my son does this in Georgia. He's a real estate attorney in Georgia, and they do $1,000 deposits, and they're all as-is contracts. They got 2 forms basically in Georgia. And I have family in New York that do this day in and day out, and I'm from Boston, and my family do it up there as well. If it's too small, the buyer is more apt to dig in their heels on inspection issues and refuse to close. You have less leverage when you're negotiating inspection issues.
Right.
Because if it's a $5,000 deposit or a $10,000 deposit and the buyer refuses to close, the seller has to ultimately hire somebody, an attorney, to sue to get the money.
Right.
And experienced litigators may ask for a $5,000 retainer.
Right.
And the buyer might be from Utah. So you got to win here, get your judgment for attorney's fees, and then hire somebody in Utah to go after the person. So there's more strife, more deals fall apart when it's too small. It can actually be too big. I had this morning. I have a man who called me, and he's selling some raw land for $190,000, and the buyer is offering to put up a $100,000 deposit. He says, Don, it sounded too good to be true. Right. I says, well, it is. There's a lot of cases out there, and I've actually litigated this in federal court when I was in my 30s. Judge Spellman was a judge, in fact, where the deposit, if it's too big, you know, that deposit is supposed to be liquidated damages. Liquidated damages is a legal concept that means, you know, when the buyer and seller are first negotiating their contract, you know, they're talking about what the seller's damages might be if the buyer refuses to close. And they say to each other, let's say you're the buyer, I say, you know, Jim, I don't know what my damages are going to be. No way to predict that far in the future. Don't know what might happen in the next 2 months. Let's agree that this 10% will be liquidated damages, which is the amount that you and I are agreeing on will be my damages if you refuse to close. If it's small, and it's a good faith negotiation between you and me to come up with a reasonable number, the courts enforce it. If it's really high, there's a bunch of cases that say if it shocks the conscience of the court, that it's obviously not a good faith effort, they can set it aside, and now me, the seller, and Don Ross, has to prove what my actual damages are if you fail to close 3 months from now. So I had this gentleman this morning with his $100,000 deposit. And what I ended up suggesting was you could do seller financing and actually have a closing. Supposedly the buyer needed 3 more months to get the rest of the $90,000 to buy this $190,000 lot. So we could do seller financing. You get the whole money, he owns it.
Right.
You know, that's no longer a deposit, it's part of the purchase price. And you, instead of 3 months, you give them 4 or 5 just to be generous. You could do that. Or you can do the most I would go up to would be 20% because developers do that.
That's right, yep.
And this is me advising the seller, have them pay you directly rather than going into escrow. That way you don't have to hire a lawyer to sue for that escrow if he fails to close.
Right.
You know, I did the closing for the gentleman when he bought the property, so I know the title was clear, so I wasn't worried about any sort of misrepresentation to the buyer, and it's raw land. So there really wasn't much for them to investigate. So it could be too small, too big.
Yep. Well, Don, I appreciate you coming on the show today.
Thank you
I've
for
learned a
having me.
lot.
Appreciate it.
Hope our audience has learned a lot, and I hope
so.
Hope you come back next month.
Oh, definitely. Thank you, Jim.
Thank you.